welcome back to the High Court Report, your one-stop shop for Supreme Court coverage.
It's June 25th, 2026. The Supreme Court dropped 4 opinions in a single day. 4. We've got a gun rights case out of Hawaii, 2 immigration blockbusters, 1 on border metering, 1 on temporary protected status, and a massive environmental tort case involving Roundup weed killer. Guns, borders, immigrant protections, and pesticide litigation, all at once.
The court typically makes waves in late June. Today was no different. That's 9 opinions released in the past 2 days.
As far as today's cases, here's your scorecard before we dig in. Justice Alito authored 3 of the 4 majority opinions. Justice Kavanaugh wrote the 4th. 3 decisions landed 6-3, with the conservative justices in the majority. The 4th, the Roundup case, came out 7-2, with a bipartisan coalition that almost nobody saw coming.
Wait, Sotomayor and Kagan joined the conservatives?
They did. More on that in a moment. And here's something that runs through all 4 decisions like a thread. Justice Thomas filed a concurrence in every single case. 3 he authored himself. 1 he joined in part. We'll break down exactly what he said and why, because his concurrences aren't decorative. They function as roadmaps for future litigation. And on the dissenting side, Justice Jackson opposed the court in all 4 cases, twice as the author. That makes her the most active dissenting voice of this entire opinion day.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about any of these cases, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know. First up, Monsanto Company versus Durnell. John Durnell used Monsanto's Roundup herbicide for about 20 years and developed non-Hodgkin's lymphoma. He sued Monsanto in Missouri State Court, claiming the company failed to warn him the product caused cancer. A jury awarded him more than $1 million.
And the EPA had already cleared Roundup multiple times.
Repeatedly. Since 1974, the EPA reviewed glyphosate, the active ingredient in Roundup, and consistently concluded it does not likely cause cancer. That conclusion lines up with regulators in Canada, Australia, Japan, and the European Union. Because of EPA's position, Monsanto's federally approved label carries no cancer warning. Federal law actually requires Monsanto to use that label unless EPA says otherwise.
So Durnell's lawsuit basically asked a Missouri jury to override what the EPA decided.
More or less. And that's the collision point. A federal law called FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act, contains a preemption clause. Think of preemption like a federal no-fly zone. States can't impose labeling requirements that go above or beyond what federal law requires. The court, in a 7-2 decision authored by Justice Kavanaugh, held that FIFRA's preemption clause blocks Durnell's state tort claim because granting him relief would require Monsanto to add a cancer warning, a label the EPA repeatedly rejected.
And the bipartisan coalition, that's what throws people. 7 justices agreed. Roberts, Thomas, Alito, Sotomayor, Kagan, and Barrett all joined Kavanaugh. Jackson and Gorsuch dissented together, which almost never happens. Jackson wrote the dissent, Gorsuch signed on. That tells you preemption law doesn't map neatly onto left-right ideology. Sotomayor and Kagan prioritize federal regulatory consistency over state tort remedies. And Gorsuch, who almost always votes with the conservative bloc, crossed the aisle to stand with Jackson, believing states should retain room to hold Monsanto accountable.
Now let's talk Thomas. He joined Kavanaugh's majority in full, but he also wrote separately 3 big constitutional concerns, none of which the majority addressed, but all of which Thomas clearly wants litigated down the road. First, he argued FIFRA likely exceeds Congress's Commerce Clause authority. The Commerce Clause lets Congress regulate buying and selling across state lines. Thomas argued it doesn't let Congress regulate how a homeowner uses products in his own backyard, which FIFRA effectively does. Second, he flagged non-delegation. EPA's power to dictate pesticide labels and criminalize violations looks, to Thomas, like Congress handing off core legislative authority it cannot legally transfer. Third, and this one gets into deep constitutional territory, Thomas questioned whether agency rules can preempt state law at all. The Supremacy Clause makes the Constitution, federal statutes, and treaties supreme. Agency regulations don't appear on that list. If agencies don't make law under the Supremacy Clause, Thomas argued, their rules arguably can't override state law. He didn't resolve the question, but he planted the flag.
So he agrees with the result, but thinks the whole regulatory structure underneath it may rest on shaky constitutional ground. He joined the majority and then essentially said, this entire framework deserves a harder look.
Case 2, Mullen versus Al Otro Lado. This one turns on a single phrase in immigration law, arrives in the United States. Under the Immigration and Nationality Act, an alien who arrives in the United States triggers important legal protections, the right to inspection by a border officer and the right to apply for asylum. The question, does someone standing in Mexico at the border, waiting to cross, qualify as having arrived?
The Ninth Circuit said yes, the Supreme Court said no, 6-3. Alito wrote the majority, joined by Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett. The court leaned on ordinary meaning. To arrive in a place, you actually have to enter it. You don't arrive in a city while you're still on the highway outside.
What prompted this case?
Starting in 2016, border facilities faced enormous surges of migrants. The Department of Homeland Security responded with a metering policy. Capping the number of asylum seekers, CBP would process each day. Officers physically stood on the U.S. side of the border and held back people still in Mexico. A class action challenged that policy, arguing those migrants had already arrived and therefore possessed legal rights to inspection and asylum processing. The district court agreed. The Ninth Circuit affirmed. The Supreme Court reversed and remanded.
So the government can legally meter border crossings.
The court greenlit metering. Sotomayor dissented, joined by Kagan and Jackson. Jackson also wrote a separate dissent. The dissenters pushed back hard, arguing the majority's reading leaves vulnerable people stranded without legal recourse. The majority responded that those policy arguments belong to Congress and the executive, not the courts.
And Thomas went further again. 2 additional concerns. First, he argued the district court's so-called declaratory relief functioned identically to a class-wide injunction, and the INA expressly strips lower courts of jurisdiction to issue that kind of class-wide order against immigration enforcement. The lower courts, in Thomas's view, executed a legal end run around that bar by labeling the relief as declaratory rather than injunctive. He called on the court to confront that evasion directly in a future case. Second, and this reaches deeper, Thomas argued that any statute compelling the president to admit aliens against his will would likely exceed Congress's enumerated powers and infringe the president's inherent executive authority to exclude non-citizens. A court, he argued, couldn't enforce such a statute against the executive.
He's essentially saying, even if Congress tried to require the president to let people in, that law might not hold.
That's his position, and it carries significant implications for any future immigration framework Congress might pass.
Case 3. Same petitioner name, DHS Secretary Mullen. Different case, Mullen versus Doe. This one covers temporary protected status, or TPS, for immigrants from Syria and Haiti.
TPS, that's the program that lets people from countries experiencing disasters or conflicts stay in the United States temporarily.
Congress created it in 1990. Syria received a TPS designation in 2012 during Assad's brutal crackdown. Haiti received one in 2010 after its devastating earthquake. In practice, these temporary designations stretched for decades. Somalia's TPS designation, for instance, dates to 1991 and still stands. The Trump administration terminated TPS for Syria and Haiti as part of a broader policy that canceled every TPS designation up for renewal, 13 total. Affected nationals sued under the Administrative Procedure Act. The Haitian nationals also raised an equal protection claim, arguing the termination reflected racial bias, citing statements by President Trump and former DHS Secretary Kristi Noem.
How did the court split?
Alito announced the judgment and wrote most of the opinion. Roberts, Thomas, and Kavanaugh joined in full. Gorsuch and Barrett joined everything except Part 3A, the section dealing with the equal protection race claim. Kagan dissented, joined by Sotomayor and Jackson. Thomas wrote separately again.
What did the court hold?
2 things. First, the TPS statute expressly bars courts from reviewing the Secretary's termination decisions. No judicial review of any determination regarding TPS designations. The court read that as a hard stop on nearly all claims. Second, even on the equal protection claim, the court concluded the Haitian challengers likely couldn't prove race motivated the termination. The administration terminated every TPS designation regardless of country. That across-the-board approach undercuts a race-specific discrimination theory.
And Thomas pushed even further.
Two additional moves. First, he argued the judicial review bar covers constitutional claims too, not just statutory ones. The statute says no judicial review, no carve-out for constitutional challenges. Thomas cited Justice Scalia's view that Congress can strip lower federal courts of jurisdiction even over constitutional claims. Second, and this one carries enormous implications, Thomas argued that equal protection doctrine simply doesn't reach federal immigration decisions. The Equal Protection Clause lives in the 14th Amendment and binds states, not the federal government. The Fifth Amendment contains no Equal Protection Clause. The 1954 Supreme Court decision in Bowling v. Sharp read one in, and Thomas argued that decision lacked textual or historical support and was wrongly decided. Bottom line, in Thomas's view, non-citizen immigrants hold no constitutional equal protection rights against the federal government when it comes to immigration status.
That's a significant position. It would shut the door on an entire category of constitutional challenges to immigration decisions. And he made a pointed observation. If equal protection principles did govern federal immigration law, then TPS itself, which benefits nationals of specific countries but not neighboring ones, might qualify as unconstitutional discrimination. He used respondents' own theory against them.
And then the fourth case, Wolford versus Lopez, Hawaii, guns. Alito authored again, 6-3, same coalition, Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett in the majority. Kagan dissented separately. Jackson dissented, joined by Sotomayor.
Hawaii, not exactly a state you associate with gun rights victories. After the court's 2022 Bruen decision, New York State Rifle and Pistol Association versus Bruen established that Americans possess a constitutional right to carry handguns outside the home. Hawaii replaced its old carry law with new restrictions designed to achieve similar ends. The law at issue here prohibited anyone carrying a firearm on private property open to the public, gas stations, restaurants, grocery stores, coffee shops, unless the property owner gave express affirmative permission in advance.
That flips the normal rule.
At common law, the default on private property open to the public works like an implied welcome mat. You may enter unless the owner says otherwise. Hawaii flipped that specifically for gun carriers. You may not enter armed unless the owner expressly says yes. The court found that unconstitutional. Alito walked through the Bruen historical analog test, which asks whether a gun restriction fits America's historical tradition of firearms regulation. Hawaii pointed to colonial-era anti-poaching statutes from the 1700s and post-Civil War black code laws from the 1800s. Both sets of analogs failed.
Barrett wrote separately here. That's the one where Thomas and Gorsuch joined her on part of it.
Barrett's concurrence made two distinct moves. Part 1, Barrett alone, rejected Hawaii's argument that this case falls outside the Second Amendment entirely because states can adjust property law default rules. Hawaii and the principal dissent argued no one has a right to enter private property without consent, so flipping the default just adjusts property law, not constitutional rights. Barrett answered, when a state enacts a property law that regulates arms-bearing conduct, it triggers Second Amendment scrutiny regardless of how you label it.
She drew a First Amendment parallel. A state law requiring express permission to wear a hijab onto commercial property would obviously trigger First Amendment review. The same logic applies here. The Second Amendment doesn't care that Hawaii dress its gun restriction in property law clothing.
And Part 2B, the section Thomas and Gorsuch joined?
That section dissected the historical analogs Hawaii offered. The 18th century anti-poaching laws targeted specific, identifiable harms: damage to crops and livestock, danger to bystanders from unauthorized hunting. And they applied narrowly to enclosed farmland, not retail establishments. Hawaii's default rule addresses no specific identified abuse of firearms. It reflects general public disapproval of gun carrying. Different end, different means, different principle. As for the 19th century Black Code statutes, Barrett went further. Louisiana's 1865 law, which Hawaii cited, formed part of a deliberate scheme to subordinate newly freed Black Americans, restrict their ability to forage and hunt for food, push them back onto plantations, and leave them defenseless against private violence.
Under Bruen's how and why test, even if the surface mechanism looks similar to Hawaii's law, the underlying purpose bears no resemblance to any legitimate regulatory goal. Barrett's closing line, Most would take it as a compliment that Hawaii's law doesn't share the same justification as the black codes.
That's a pointed way to end a legal argument.
It landed. Kagan's separate dissent attacked the Bruin historical analog test itself as unworkable. Jackson's dissent, joined by Sotomayor, called the methodology a framework that systematically produces predetermined outcomes and leaves states no effective path to gun regulation. Stepping back across all four, the authorship picture tells a story. Alito wrote 3 majority opinions in one day. That kind of output concentration signals where this court's center of gravity sits on high-stakes contested issues. Kavanaugh's Monsanto opinion, the one outlier, produced the most ideologically scrambled result.
And Thomas wrote or joined a concurrence in every single case.
Every single one. And you see a deliberate pattern in what he flagged. In Monsanto, he targeted the constitutional foundations of the administrative state: Commerce Clause limits, non-delegation, and agency preemption. In Al Otro Lado, he targeted judicial overreach into executive immigration authority. In Doe, he targeted the constitutional basis of federal equal protection doctrine itself, going after Bowling versus Sharp directly. These aren't random observations.
Thomas uses concurrences to invite future litigants to bring the exact challenges he outlines. Watch for those arguments in lower courts over the next several years.
Jackson, on the other side, dissenting in all 4, she wrote or co-authored dissents in 3 of the 4. In Monsanto, she argued alongside Gorsuch that states should retain authority to hold pesticide manufacturers accountable. In Woolford, she challenged the Bruin methodology at its core. In Al Otro Lado, she authored a separate opinion beyond what Sotomayor wrote. And in Doe, she joined Kagan. 4 cases, 4 dissents, multiple authored opinions. Jackson came to fight on Opinion Day.
Here's the bottom line on today. 4 cases. Alito authored 3 of them. Kavanaugh authored the 4th. Thomas left fingerprints on all 4. Jackson opposed all 4. The most surprising result wasn't the gun decision or the immigration rulings. It was 2 liberal justices crossing the aisle in an herbicide lawsuit, while Gorsuch crossed in the opposite direction to stand alongside a liberal colleague against a corporate defendant.
And the court planted 4 separate sets of seeds for the next decade of litigation. The Thomas concurrences alone could generate years of follow-on cases. The Supreme Court of the United States, always thinking several moves ahead. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about any of today's 4 cases, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
If you email us about Thomas's concurrences specifically, we will dedicate an entire episode just to that. That's a promise.
Talk to you soon.